you don't want this to happen to your brand. Put a lot of thought, you put a lot of energy and everything that you have into the creative ideas behind your brand, then the last thing that you want is someone using them without your permission. In this episode of Retail Fashion Business, I'm gonna share with you some information and all you need to know about copyright, trademark, and patent, and the difference between just a patent and a utility patent. You ready? Let's do this. Intellectual property. So intellectual property refers to the ownership of intangible and non-physical goods. These are things that you don't want to actually touch. It refers to something like a filament from your mind, something that comes from your head. So it's the only tool that you can use to protect your ideas is to have your own intellectual property protected. I'm going to give you more information about trademark, copyright, and patent, and the difference between just a patent and a utility patent. So the first thing that we're going to talk about is trademark. So what's a trademark? You see the TM, when you have a logo and then you have a TM on the right side of it. Looks cool, right? You can probably put it on your name, right? Nuh-uh, not exactly. It's not really expensive, the trademark. The thing is, trademark protects your logo. So if you have a logo and you put a TM there, no one can actually use it without your written consent. Trademarking your logo will stop others from using it without your permission in writing, not just, in words. Me saying it, yeah, sure, use it. No, it should be in writing. When no claim of color is made and the trademark is presented in black and white, in most cases, the registration is presumed to cover your logo in any color that you wish to use it for. If you know the countries you would like to expand your business in the future, for example, your business is based here in the Philippines and you'd like to expand it in Southeast Asia. What are the countries in Southeast Asia? I don't know. I don't want to make a mistake. You have to register the trademark so you will be able to use it in advance to avoid anyone else taking it from you. Imagine if you have basic name like water. You want to trademark the name water to your brand here in the Philippines and you put a trademark in that for global. You can have it trademark also in Singapore, in Malaysia, Indonesia, probably Hong Kong and other. It depends on the country involved. You can also apply for a global patent, but we'll talk more about that. When you register international trademark through what we call the World Intellectual Property Organization or the WIPO, it allows your trademark to be recognized and be protected by more than 90 members globally. I don't know how many countries there are in the world, but 90 sounds a lot to me. That's a pretty good way to making sure that your brand is not used in the wrong way and that you're able to monetize your brand even if it's used in any of the 90 countries involved. For a list of that, you can check out their website on the countries that are involved in WIPO. Trademark length of protection lasts about 10 years. That's the regular term. But it's worth thinking ahead in terms of an expansion plan. So whatever your expansion plans are, if it's in a country not protected by WIPO, check it out first so that if you do business in that country, your brand will be well protected. What's the cost of that? On a scale of 1 to 5, with 5 being the highest, I put it at about 2 out of 5 in terms of it being very expensive. You may pursue legal action if you have a trademark when someone is using your logo or someone is using a similar logo for similar products or services, which could cause confusion. There's a funny thing I think somewhere, a country in South America used the logo of Starbucks. And the name is not Starbucks. It says, "We serve. We proudly serve." That's the name. It's a fake Starbucks. It shows the logo of the girl. I think she's a mermaid. It shows, "We proudly serve." So people think it's Starbucks, but it's not. So that type of problems you may encounter with your brand just because it's so recognizable. Like, the M, the golden arches of McDonald's is very famous. So if you use that for your small business, people would think, oh yeah, it's a McDonald's, but it's not. Those are trademarks that you have to be careful of. You can also pursue legal action when someone is intentionally imitating your logo. And this is a funny thing also, which might cause defrauding or take advantage of, or something that could potentially damage your brand if they use it incorrectly. Imagine someone using your brand. For example, you're doing fashion and it's high end and someone's using it for cheap fashion. That's why some fast fashion brands, I won't name the fast fashion brands, sometimes get sued by high fashion brands based on the logos that they have and it's being used by fast fashion brands. You know, difference of a $2,000 coat being used for a jacket that's worth 20 bucks, perhaps. That's a problem you don't want to have. Trademark. If it's a spoof, you still have to make a declaration that there's no copyright infringement involved in it. I'm not very keen into the legalities of that, but I'm pretty sure if you use, for example, the logo of, let's say, NBA, and you make it a funny looking logo, you know, the logo of the NBA is Jerry West, right? You play around with it and use it to make people think that you switch it to something else, then most likely you'll get a cease and desist order sent to you. I've had that kind of experience from one of my sellers before in one of my Soul Stamp stores, when someone used something similar to that and they had a cease and desist order sent to them by the bigger company. You don't want that kind of problem with you. Imagine if you have 1,000 inventory and you have to stop selling your stuff. That would be a disaster, right? Moving on to number 2, which is copyright. Copyright protects original works of authorship, including the works and drafts of photography, design, art, and illustration, but not the ideas, trends, or styles presented in the works that's involved in it. Copyright does not need to be registered at all. You don't need to register that. If you are the creator of the work itself, or for example, let's say the style of photography that you use, you will automatically have copyright protection for you. That's automatic. The copyright symbol, you know, the circle with the C inside of it, is a useful way to claim copyright of that style or whatever it is that I mentioned. Simply mark your work with that C symbol along with your name and the year it was created. Always keep a record of your research and the development from the initial sparks of the idea that you have to the finished product itself. Why? Because you want to keep notes of the dates and the mistakes and the changes that you have, like the versions, like you have version 1, 1.1, version 2, 3, and onwards, to have all the proof that you need if it's ever disputed in the end. Does that make sense? The length of a copyright usually lasts for as long as 70 years. It's between 50 to 70 years. That's pretty long. 50 to 70 years. So make sure you're protected with the copyright. What's the cost of that? On a scale of 1 to 5, with 5 being the highest, it's free. 0. So I'll put there at 0, not even 1. Right? You just have to draw it and write it. You can always pursue legal action when someone is copying, distributing, or modifying your work without your permission. Imagine if your work is your signature, and your signature, let's say, for example, I think Futura. Futura's signature is very iconic. If you play around with this logo and pretend that you are Futur or something, copy his logo, that's a copyright. I think it's a trademark now too, because, you know, it's worldwide. I'm just giving it as an example of copyright. You know, if you change it that way, you can pursue legal action towards that person that actually uses that. Another example would be someone who modifies parts of your work to make it seem like it's their actual work, but your unique stamp of creativity is still very evident in that work. You see a lot of those examples being shown online when that actually happens. That probably is something up for discussion with lawyers. It's not my place to make a decision or make an opinion without the facts of it. You have to see the legalities of it. If Nike has pursuant acts towards it, if Nike has the rights to pursue towards legal action towards that kind of thing. It depends. It really depends if you really want to pursue legal action. But if not, if it helps their brand, they don't have to. If it's a custom pair and it's just, you know, one of one or hundreds, I think they could pursue because their logo is being used. For example, if you use a pair of Air Force Ones and then put your logo in there without permission of the brand, they could still pursue legal action. Yeah. I mean, if you bought 100 pairs of those and you sell it off, because we had a plan before using another brand to buy like 100 pairs of them, put our logo there. Our lawyer said not to do it because you might get a cease and desist order sent towards it. You wouldn't want that. You don't want a bigger brand pursuing your ass. That's for sure. And by the way, before we move on from copyright, I want to tell you more about what's a NDA, or a non-disclosure agreement. An NDA is a confidential agreement between you and the party who shared confidential material, knowledge, or information, and it's used to protect non-public business information. So that's an NDA. You hear it all the time, right? Can you sign an NDA before we discuss something with you? So that's an NDA. Moving on to number 3, which is a registered design. You know the circle with an R? That's a registered design. What is a registered design? A registered design sometimes is referred to as a design patent. It's a patent that protects the appearance of a functional object. Like for example, this mic, if it's shaped uniquely this way and and it's being held on by this. It's a design patent if you're the first one to actually do it. The seat belts made by Volvo back then, it's a design patent that they made, a three-way seat belt, because seat belts before were just, one. Now, this 3-point was made by them, and they probably held it for years, but they decided to share it because it's an important safety feature that every car in the world needs to have. It protects the visual design of objects that you make. Like, for example, this tripod holding the camera in front of me right now is a design patent, perhaps, such as the shape or the composition of pattern and of color, perhaps. I mean, whoever colored the basketball to be somewhat orange probably is a patent as well for every brand. I mean, colors itself is a patent. If you're able to create a color that only you have created, it could be named under you. Registered designs are only valid in countries where trademark is registered. It's not valid in countries where trademark is not registered. Don't forget that. A registered design can last up to 14 years. And it is extendable. You can extend it for another 7 years, another 14 years, but that's usually the maximum. Take note of that. What's the cost of that? On a scale of 1 to 5, with 5 being the highest, I'll put it at 3 out of 5. Why? Because of all the fees and the paperwork that needs to be done in each country that you will pursue that registered design that you have. You may pursue legal action when someone is using or applying your registered design to their own products without your permission. Again, the permission has to be written and signed by both parties involved. That's why you have collaborations, because a collaboration is a handshake deal between two different persons or brands. If you're friends, I would still say protect yourself through like just a one-page contract. Like you and this person, for example, brand A is doing a collaboration with brand B. Brand A gets 60% of every proceed and brand B gets 40%. Clear. And it will run for approximately 90 days upon the first day of release. And after that, if brand A still continues to sell something of brand B's products, they are not allowed to do it anymore. Something like that. Very simple terms, because brand A allows brand B to use their brand and vice versa. Past the 90 days or the 180 days that you're supposed to use it, it's already a violation of the terms and agreements that they have. It depends on you and how you shake hand on that type of deal. Like, for example, when Sosam did the collaboration with Mosimo, it was supposed to be a 6-month deal, and we had it extended for another 6 months just because we had the second collection coming up. That was it. 6 months. If you're going on sale, they have to put it at the back or up to the outlet. Let's move on to number 4, which is a PAT, or what we call a utility patent. A utility patent will protect the functionality of new technical inventions, like what I mentioned before, the seat belts, 3-point seat belts. It's mostly used for fabrics or when your design has a high-tech aspect on it. Like, for example, Nike created like the dry fit material. So for a time, other brands could not use it, and some other brand created some other technology for moisture wicking technology for their clothes. So it's something that they do. I mean, clothes are clothes, but then new technology comes in, a new fabric is created, perhaps someone holds the patent for that, and therefore you cannot use it. For example, like different types of cottons, different types of satin, different types of zippers, buttons, rivets, everything. There's a lot. It's used most for fabrics when, again, there's a high-tech aspect of it. A utility patent will stop others from making, using, or selling the invention without your written permission. When a patent is granted the invention, it becomes the property of the one who invented it, which can be bought, sold, rented, or hired, just like other assets. It's like rent. The idea that you have, for example, you created a particular type of zipper that, it's not zigzag, something crisscross, and it's a zipper that you created. Other brands can use it and they have to pay you for that. Utility patents are only valid in countries where the trademark is, again, registered. It's not valid in other countries where it's not registered. So someone can actually use that patent that you have. You can apply for a patent in countries you intend to trade in the near future before making it public, before your company goes public, or it will not be able to register the patent. A utility patent can last, again, up to 14 years. You can register it for 1 year, 2 years, 5 years, 7 years, up to 14 years, and it can be extendable for as long as you like. On a scale of 1 to 5, with 5 being the highest in terms of costing, I would put this at 4 out of 5. This is probably the most expensive thing to do just because you're protecting your ideas. If you watch Shark Tank, a lot of the people who are selling their product or pitching their products, they're being asked, do you have a utility patent for this invention or creation that you have? Because if not, we will just go to Alibaba and order that stuff, have it made. I remember the guy that had colorful toilet seats underneath, the lighting. You can change the color and the mood every time you sit down. And I think he didn't have the patent for it. So China just obliterated his entire design over that. It's out there. He was supposed to be selling it for a certain margin. Now it's so cheap. Protect yourself if you have an idea. As a last reminder for you, always consult a law attorney. It's always best that you consult a law attorney that knows his stuff when it comes to patents, utilities, trademarks, and everything else that I mentioned. If you have legal doubt or you think someone is trying to copy you, hire a lawyer to ask the infringer so that they can resolve the dispute right away. You have to nip this issue right away in the bud if you're a brand, especially if you're a startup brand. You have to protect the integrity and the value of the brand that you have. It's really important because if you're a startup brand and someone uses your brand, it could be the death of your brand right there and then. Hire a lawyer and ask the infringer to resolve the dispute and find the most effective way to do it. And if they fight, you can always sue them for an X amount of money depending on what your lawyer tells you. They are expensive, I know that for a fact, but the cost will be minimal compared if you need to go to court, for example. You don't always have to go to court because of that. Court action should always be your very last choice. So if you never gone to court, it's expensive. You don't want to go there. If you don't have the finances and the time to actually do that, do not go into court. Try to settle it in a manner of just, doing it behind the scenes. Do you have a brand that you have? What do you think would you want to pursue now, knowing what you knew in today's episode? Would you pursue patent, a copyright, or maybe a trademark perhaps? Let me know in the comment section.